This computer, go ahead. All right, I'll keep letting people in. Andrea, I'm going to turn it over to you.
Thank you so much. I really appreciate everybody being here. I know we have a lot of questions, and since I am not the woman with the answers, I will turn it over to Judge Jones. I know she wants to make some initial remarks.
I don't know if Judge Jones, she's been trying to connect.
Okay. Do you see her, Alan, in the waiting room?
There is no one in the waiting room.
Okay.
I'm here with us.
There
now.
she is.
Can you hear me?
Yes.
Okay, very good. Good afternoon.
How are you, Judge? I think I had just said that you could, if you had some remarks you wanted to make initially, we're all excited to hear about the process.
All right, very good. So what I'd like to do, I don't know if you had the opportunity to identify who is with us this afternoon. I know that we invited the criminal defense bar section from the Akron Bar Association, and then we have some of our colleagues with us. I see we have Magistrate O'Connor with us, we have Judge O'Brien, we have Judge Oldfield, we have, I think, Judge Rowlands with us. Let me see who else we have, and forgive me if my other colleagues that are with us and that I cannot necessarily identify.
Judge McLaughlin.
Judge McLaughlin is with us, very good.
I'm here, it's Judge Bro.
Judge Bro is here with us. I know
Judge Ross is here.
Judge Ross is with us. I'm not certain if we have Judge McCarty with us or Judge Croce. So, okay. And then I'm not sure if we have any judges from the Stowe Municipal Court with us this afternoon. I'm sorry, from Stowe, do we have Judge Hoover, Judge Coates?
Judge Rowlands is on as well. I might have said that.
Okay, very good. And then I'm not certain if we have any judges from Barberton, either Judge McKinney or Judge Lanzinger with us. Okay, I don't think they're with us. And then I'm not certain if we have any judges from Akron Municipal Court with us. I know that we have court administrators with us from, I believe, Akron. And I know we spoke to administrators from Stowe yesterday as well. I think I also see Greta Johnson and Deb Matz. I see Joe Kodish with us. I see Claire Dickinson, I think. He is with us as well. And forgive me if I've missed any other public officials. I see Attorney Gertrude Wilms with us from the city of Akron. Forgive me if I've missed anyone that I can't see or identify in terms of a phone number. So we have 63 total participants right now. So with that, again, Attorney Whitaker, we appreciate you setting this up. Alan Nichols, we're very grateful for the organization of this meeting here today. So just to start with, I know that we've provided the process overview. Again, if you don't mind, if you're not speaking, if you could mute your device, we'd appreciate it. I think it'll reduce the feedback. But Judge Oldfield, we can provide that process overview. But originally, I think the discussions began amongst the general division.
Judge Jones, are you able to see the screen now?
Very good, yes. And then if you don't mind too, I'd like to, just stop right there if you don't mind.
Sure.
You'll see in the overview, again, the general division judges really began having the discussions internally after the formal announcement was made by the State Public Defender's Office, and you can see it's referenced in my overview, that they were going to begin increasing funding from the state level to the local level up to 70% for the first fiscal year. And then as you can see that notation, up to 90% for the second year. That was for indigent defense costs. There was also a separate announcement, and you can see that here on the screen, that the State Public Defender's Office was also going to increase budgetary funds to state or in local public defender's office, of course, with parameters and requirements to be met in accordance with those increases in reimbursement. From the Ohio Public Defender's perspective, of course, their main priority is providing effective and efficient representation for indigent defendants. So I can certainly provide you with that overview and then the announcement that was made back in July of 2019. As many of you know, following that announcement of the Bar Association, I think actually Judge McCarty was either the chair of the committee at that point, and if we could just back up to that paragraph. There we are, Judge Oldfield, thank you. The Bar Association put a meeting on. I believe there were individuals from the county executive office were there. I think it was held in the ceremonial courtroom. And the discussion about the reimbursement rates being increased was provided to the bar. And then there was also the discussion regarding audits of certain attorney billing, just to see where the reimbursement rates in its totality would take Summit County, working with the State Public Defender's Office.
Attorney Fickus, I'm going to ask you to mute your phone, please.
Thank you, Attorney Fickus. So we'll go ahead and move to the next page. And then again, of course, there were meetings amongst the general division judges, and ultimately, and we'll pause right there, Judge Oldfield, thank you very much. The ultimate determination that was made in an effort to truly improve our system overall in Summit County was that the general division judge's goal would be to make the felony appointments to the cases. We do believe unanimously the fundamental theory that judges that preside over felony cases should exercise their obligation for the oversight of those cases and ultimately to appoint to those cases and oversee the cases to their conclusion. But we also believe, in addition to that policy, direct benefits are expediting the pretrial process at municipal court levels, streamlining felony reductions at the municipal court level, reduce and limit incarceration days on felony arrests, reduce and eliminate a second or third or fourth appearance in municipal courts for felony offenders because the public defender will be in place for that first appearance, reduce or eliminate lawyers' required attendance in municipal courts, reduce and eliminate arraignment appearances in common pleas court, streamline the arraignment process in the common pleas court, reduce appointed attorney appearances, and truly promote the effective assistance of counsel by having designated public defenders attend arraignments at the municipal court levels in a structured, organized format. So with that, from there, we did meet with the county executive office. We met with Attorney Kodish from the local public defender's office. We had discussions with the chair of the Public Defender Commission. And then, of course, we had discussions with the administrative judges of all three municipal courts. So essentially, there are just a few things I would like to point out to you before we get into some of the details and then answer any questions that you have. But it's our understanding also, as part of a systematic overhaul, that the county executive office will be taking to county council, I believe on November 9th, legislation to formally increase the reimbursement rates for indigent defense counsel. And I think either Greta Johnson or Deb Matz can address that here in just a few minutes. And then we do have some I guess, process overview points we would like to discuss with you, even in terms of practically how it will work in all three different jurisdictions. And we do want you to understand, I just think overall, that pretrial services will be prepared, at least in Akron and Barberton, where they have a presence now, to provide those pretrial risk assessment and bond reviews for that first appearance. Attorney Kodish has assured us that he will have counsel present for those arraignments funded by the Public Defender's Office. Tim Young, who is the state public defender in Ohio, has confirmed for us that those lawyers in the Public Defender's Office are qualified to handle those appearances. And it's our understanding, based on the funding expansion from the state to the local level, that Attorney Kodish is going to work with all three municipal courts and expand the staffing that is present, not only to address the arraignment issue, but also to handle misdemeanors in accordance with the protocols that are associated with the funding expansion from the State Public Defender's Office. So with that, let me just make sure that I've covered everything in our initial overview, and then I may be able to pass it on to Judge Oldfield. So before we do that, though, Greta or Deb, would you like to maybe confirm for me that the legislation is going to actually be passed or at least introduced on November 9th?
Sure. So that legislation will go in front of council on November 9th with an effective date of January 1st. And the increases that we're taking to council are the same rates that we shared with the group. I think Attorney Laybourne, Attorney Munier, I can't remember who the other defense attorneys were involved in that meeting, but there will be a sliding scale based on the reimbursement rate from the state of Ohio for the indigent defense. I don't know if I'm able to share the screen. I'd be happy to share it if I can. Give it a try here.
Okay, and then while you're doing that, Greta, the other thing that everyone will become familiar with is we are going to transition to an electronic billing system in the county in an effort to provide further oversight of actual attorney billing, so that we will move from the standard paper system that we have to an electronic data collection system, not only in the general division, I believe also in the juvenile court, in the municipal court, and then ultimately I think the goal is at the state level, from Tim Young's office, they will have a statewide electronic billing system put in place that is supposed to come into effect at some point in 2021.
Judge, if I could just make a real quick correction.
Sure.
The way that attorney fee affidavits will be submitted is going to continue to be on paper. However, the process is going to change so that those the fee apps and any other supporting documentation is going to come into one central location, because we are going to input data from those applications into a database. That's the electronic portion of this.
Okay.
And then ultimately, as the judge mentioned, our goal is, once the Ohio Public Defenders Commission completes their online system for filing fee applications, we will participate in that online system so that you won't have to submit paper anymore. You will be able to do it online.
Right. Very good. Thank you. And I think the intent, although anyone could speak to it, I know again, Deb and Greta have spoken to Tim Young, but I do think the intent from the state level is to have a more global oversight of the billing practices of lawyers who are appointed to represent indigent defendants. We will also tell you, we were notified from the Bar Association that they will no longer be maintaining the appointment list, although the system will stay in place that was first originated in accordance with the Ohio Administrative Code. And so the General Division will be in a place where we will be able to maintain that list. And one of the changes we are going to make, before I think you could only apply 2 or 3 times a year, but we will make it a rolling process, so that if a criminal defense lawyer chooses at any time that he or she would like to submit an application to be on that list, that will be an option at any given time. The makeup of the committee, though, that oversees that appointment list will remain the same. The individuals required to be on that list are identified in the Ohio Administrative Code. So I'm not sure if Greta has that information.
Judge Croce just joined us.
Oh, excellent. Very good.
I'm on my audio though, only at this time.
And Judge Jones, if I could just mention, I think we need to finalize procedures for how we're going to handle the appointment list. Since all of the different courts are ultimately responsible for their own appointments, I don't know that everybody wants to, that one court wants to be responsible for everybody's list.
Right.
So I think we ultimately have to finalize the procedures on how exactly the appointed counsel list is going to be.
That's exactly right. And when we actually spoke to the Stowe Municipal Court earlier this week about that very issue, whether the municipal courts will choose between Akron, Barberton, and Stowe for their misdemeanor list to work together and have one list, or whether they would choose to have 3 separate lists in each municipal court, that would be within their authority. But as it relates to the felony list, and then if the municipal courts preferred that one list exists, felonies and misdemeanors, we're willing to work together with them. Ultimately, that is the municipal judge's decision.
And Judge, we do plan to have at least one additional staff member who will be ultimately managing all of these applications. So we will not ask the individuals in the fiscal office who currently process those. This will be a separate staff member who would go through, make sure, you know, all the I's are dotted and T's are crossed, and all of that is done before the application is processed. The one thing that may be a challenge is that as we transition to these new fees, there will have to be an interim billing by the defense bar. So if you have a case on which you are appointed in, let's say, mid-December, all of your work that's done in the month of December, you'll have to submit a bill under the current payment schedule by the end of February. And then all of your additional work in the months of January, February, until whenever that case may end, will be under the new fee structure. So what we're looking at is everything through the end of December 31st of this year will be under this current fee structure. And we're asking that you will submit your interim bill on whatever case you still have pending for that work. Deb and I will be putting together a one-sheeter for the defense bar with the new process, so that hopefully it will be easy to manage. But again, we still have a few details to work out. We're actually demoing the product that's been created on Monday afternoon. So we should have some more answers by the end of next week.
All right, thank you very much, Greta. Anything else, Greta or Deb, before Judge Oldfield moves through the specific policies and procedures as we move forward?
Sure, just one last thing, Judge. There is currently a local ordinance that requires defense attorneys to submit their fee app for payment no more than 60 days at the conclusion of the case. So that is going to actually be enforced beginning in January. So fee apps will not be accepted after 60 days of the conclusion of the case, because we only have 90 days total. So that gives the county 30 days to get it processed. This new product or program that we have doesn't eliminate the need for us to continue to send the paper down to the public defender's office for reimbursement. So we still need some additional time so that we can get reimbursed as well. So I think that there have been many times where fee apps have been received and processed after that 60-day mark, but we're going to have to enforce that because of the new process that we're going to be using through internal audit.
Okay, thank you very much then for that.
Judge Jones,
Yes.
this is Judge Ross. Can we just ask Greta to let the bar know what the hourly rate will be increased to in this legislation, if there's a change to that?
Say that again.
The hourly rate for attorneys?
Did I not have that up? Yeah, I'll pull all of that up and I'll get it sent out.
Okay.
Yeah, because it's a change to, it's a different rate structure.
Yeah. In fact, I can share it real quick here and then I'll drop off.
The rates and the caps are all increased.
Yeah, so the caps are first and then you'll see the hourly reimbursement rates here at the bottom.
Greta, we lost
That's
the
not
spreadsheet.
visible. We lost the spreadsheet.
I have it.
There it
Hold
is.
on. Sorry. Well, I'll tell you. So we are currently at this time being reimbursed at the state by the state at a rate of 70%. So that is an in-court rate of $60 and an out-of-court rate of $60. So at this time, with the reimbursement from the state being 70%, that's where it would fall. Now, this is not going to be a situation that if the reimbursement rate changes from the state, we're not going to call you on a Monday and say, okay, the rate changes on Tuesday. We'll be doing it on the state fiscal year. So there will be plenty of notification.
And Judge McCarty just joined us as well.
Oh, excellent. So I think that we have then all 10 general division judges with us. Very good. So, and then just before Judge Oldfield goes through the specifics of the process overview, as I indicated, Attorney Kodish has worked with us and has committed, and I think he confirmed again yesterday or within the last 2 days, he is prepared when we begin the process to have the individual public defenders present in all 3 municipal courts to provide that representation at that arraignment. But with that, Judge Oldfield.
Thank you. I also want to note we also have Magistrate Amber Crow here from Akron Municipal Court. So if we've missed any other magistrates or judges, other officials, please let us know. So I'm here to talk to you about how the process is going to work, recognizing, of course, that it's a new process and change transitions sometimes have some hurdles. So I would encourage you, if as you're working through these hearings and that kind of thing, you see something that we've missed, please reach out to us. We have Director Defabal on the line as well from Pretrial Services and Adult Probation. And we're committed to making sure that this works the way that we believe that it will. As you all know, an individual, when they're charged with a felony crime in a municipality, appears in one of 3 municipal courts. Up until November 4, the way that it's typically been handled is that the individual appears initially without counsel, sometimes without a prosecutor there. I know that during the pandemic at Akron Municipal Court, I think that had been modified to some degree. Within 24 to 48 hours at Akron Municipal Court, and sometimes longer in Stowe or Barberton, private counsel would appear then for a second hearing, or sometimes called a felony status or a second arraignment. And that lawyer, one of you, would show up and talk to that client and obtain the information from pretrial services and make whatever bond argument was appropriate. Now we're going to have a lawyer from the legal defender's office present at the initial arraignment in each municipal court to handle those initial bond arguments. And pretrial services is committed to ensuring that the defendant's criminal history, whether they have any pending or active cases, all the information you would normally get as private counsel will be communicated to the attorney from the legal defender's office so that it is a meaningful bond argument at the first appearance. Our hope is that it eliminates the need to have a second appearance in any of those municipal courts. Attorney James, I'm going to ask you to mute your phone. Thanks. We're hoping that it will eliminate the need for anybody to have another appearance, although we recognize that issues come up from time to time following that initial arraignment that are required to be handled in those municipalities. Within 24 hours of the initial appearance, the common pleas judges will be appointing an attorney who will handle the case through its conclusion at the felony level. That attorney will be appointed by the common pleas court designated judge, and we have a rolling schedule, and I will share that with you in a minute. The judge's staff will obviously have information about whether there's prior counsel so that we don't have situations where 2 different lawyers are appointed. I know that's happened in some instances. And so our hope is that, that will eliminate, once that initial appearance is complete, the attorney for the legal defender's office's responsibility is concluded. And that private counsel will handle the case as you normally would have. How will you be notified by our court? Our intention is to create a notification through our system that will notify the attorney who's appointed of the appointment and of the municipality from which it originated. That will be an electronic notification, and we're hoping to also send it to you by text. I know that in the past, sometimes municipal courts have made telephone calls. That is not going to happen at the common pleas level. So we're going to encourage you to make sure that we have active and updated email addresses and cell phone numbers so that we can communicate with you electronically. That notification will also notify you if the unfortunate event occurs that another attorney is assigned through a municipal court. That won't be happening in Stowe. We're hoping to have complete collaboration with Barberton and Akron. But in the event that that does happen, you will have that information as well. And then you amongst the criminal defense part can communicate as colleagues about that. Recognizing, of course, that the attorney appointed through common pleas court is the attorney who will have responsibility for the file through the conclusion of the felony and whose work will be authorized by the common pleas judges. The case will then proceed to indictment just as it normally would. In the event that there is a misdemeanor reduction, we are working out a scenario where the public defender's office will agree to take those pleas at the municipal courts for private counsel to eliminate your need to come there. That's something new that Joe Kodish and I discussed this morning after talking with Prosecutor Wilms yesterday. And Judge Jones and I have been trying to work out the details and the specifics of that. As private counsel, obviously you are responsible for, obviously the communication with the client, et cetera. But to the extent that it does resolve as a misdemeanor reduction, our hope is that we can create the system that the legal defender assigned in that court can handle that plea and eliminate your need to go to the municipal court. So as Judge Jones indicated to you, the efficiencies are clear. You will no longer hopefully be required to be at the municipal level, except if there's a preliminary hearing in Stowe. Obviously you are responsible for that as the counsel appointed through common pleas, but it will eliminate also your need hopefully for second appearances or felony statuses in other jurisdictions. Now, typically when your case is indicted and it's bound over to the common pleas level, then there is an arraignment day in common pleas court. We have eliminated that as well. And we're doing that for efficiency for the attorneys. So you will no longer, as of, I believe, November 14th, which is a Friday, there will not be an arraignment day that day. And that is because once the case is indicted, it will be randomly assigned to a Summit County Common Pleas General Division judge, and that judge will handle the arraignment in his or her, well, let's be honest, in her call day. And so please keep that in mind. Knowing that now, what that means is that you won't have the arraignment day until you know what judge you have after indictment. We will show you the forms that we intend to use with defendants so that it's clear how to communicate with them. But please keep that in mind. So in that way, we've also added an efficiency for the attorneys, and we're trying to eliminate your need not just to go to 3 different municipal courts for arraignments, but also to come to common pleas court on Wednesdays and Fridays for arraignments. You can now handle the arraignments for your clients in call days. Our hope is that you'll have some information, et cetera, that you wouldn't otherwise have at the arraignment. So pretrial services is committed to giving that information to you as private counsel to the extent that you would have had it at the municipal level. You'll certainly have it at the time you assume representation for the client. If anybody has questions, you can start typing questions in the chat box because we'll address those at the end rather than having everyone unmute and ask questions. That seemed to work well yesterday. So please keep that in mind. The question has been asked of us, how will you know who has been arraigned so you know how to appoint lawyers? We're working with pretrial services. We're working with the prosecutor's office. In Stowe, there's a designated court employee. We hope that once we have complete collaboration with Akron and Barberton, we'll also have court involvement in that process as well. But ultimately, we will receive a list every day with the individuals who received an arraignment in custody or who received a felony summons and appeared. And that way we will know who needs an attorney appointed. Pretrial services already handles the indigent affidavits for defendants in custody, and we're asking them to continue that practice as well so that it's clear who's required an attorney. So that is the first part of this presentation, is the operational plan and the process and how it will work. The next thing that I want to share with you is the appearance. So the initial appearance in municipal court, as you know, typically had a form that the defendant received that you participated in that gave you the defendant's name, perhaps any associated cases, the grand jury date, and the arraignment date. Obviously, we will not have an arraignment date on that form now. We will still have the grand jury date and companion case information, and we're working with the legal defender's office to ensure that they take time to provide us with accurate and detailed contact information for the client you will be assigned, so that you'll have their cell phone number, their email address. Obviously, if they're in custody, you can reach them at the jail, but sometimes people get out of jail, and the hope is that you'll be able to get from that individual what kind of contact information that you need. So one of our requests and Attorney Kodish has worked with us to go over this form, is that we're going to ask those lawyers at the initial appearance from the legal defender's office to provide good contact information for each defendant and include it on this appearance slip. That's one point of contact for that defendant. Once you get an appointment from the Common Pleas General Division, we're asking you to notify the client that you have been appointed as their attorney. We're also asking the legal defender's office, as one of those checks and balances, to create that list of individuals who have those appearances so that we can make sure that we don't miss anybody. The second point of contact for that defendant is that we're asking the defendant to call this central number to find out the results of the grand jury hearing. That defendant can also call that number to find out who's been appointed to represent him or her. And obviously the notification that any failure to appear for an arraignment will result in a warrant. So in that way, our hope is that you as private counsel will be able to notify your clients within 24 hours of receiving the appointment, hi, my name is so-and-so, and I'm your attorney that's been appointed through Common Pleas Court. Again, in the unfortunate occurrence that another attorney has been assigned from another jurisdiction, our hope is that you as the criminal defense bar can work together to handle that matter together, recognizing, of course, what we've already instructed, which is that the work done through the general division is the work that is authorized through the general division through the conclusion of the case. The last form that I want to share with you, well, there are two. One is our assignment schedule, and that's always going to be available at that central office. Judge Jones, as our administrative judge, has graciously agreed to handle the first month. I've been assigned the second month, and we're hopeful that within 30 to 60 days, people will be able to notify us of, hey, this is something you didn't think of. Hey, this is a problem that we just discovered, and we'll be able to work through those kinks before we turn it over to the rest of our general division colleagues. It's just like our duty judge assignment. So every single judge in the general division will do a month, and then it will re-rotate. And so this assignment schedule will be available for you in the event that you need it. And you can call that central number as well. Finally, we have updated and we are continuing to work through the kinks so that we can adopt new local rules that identify, number one, the assignment process, because as I've told you, at the time of the indictment and the bind over is when the case will be randomly assigned to a judge in the general division. And so that process will continue just as it would have in your arraignment day in front of Magistrate O'Connor. It will be done through our computer system. But the other thing that we are changing is our local rule now. We're instituting one regarding the appointment of counsel. It will coordinate with Ohio Superintendent's Rule 8 using the factors that we as judges are required to use. And we have agreed as a Common Pleas Court to maintain that list and its information, at least for our cases, and certainly as Judge Jones indicated, in the event that the municipal courts want to work together and have one comprehensive list, we're happy to do that. But the Common Pleas appointment list has a couple changes that I want to make sure you all are aware of. Number one, you obviously have to have an active email address, a working phone with a secretary or voicemail, and the ability to connect via video and audio given the situation with the current pandemic. We've had some difficulty. You've all been wonderful about working with each other to borrow a computer or an office, but we want to make sure you understand that that's a requirement to be on the list because we don't know how long the situation is going to be that we're going to be handling things by video the way we've been doing it. The other thing that we have added is a rolling application process. Because of the staffing at the bar, they were only able to review that list twice a year. And we have decided as a Common Pleas bench that we're going to review it monthly so that you can every month, by the end of that month, reinstate, renew, upgrade it in the event that you have some other qualification that allows you to take different cases and you won't have to wait until twice a year. So hopefully that is an added benefit for you as the criminal defense bar as well. I see in the chat that a question has been requested. If the lawyer from the legal defender's office's representation ends at the conclusion of the initial arraignment and it takes up to 24 hours to have them a private attorney appointed, then during that time, are they unrepresented? Well, I mean, Pat asked that. I think that's Pat Summers, but it's going to happen just like it happens now, Pat, which is that they appear and then that day they get a lawyer appointed. That same thing is true. So I say within 24 hours, but really it'll be by the end of the day in which they've appeared. And so I don't think that you're going to have that problem. I don't think that's been a problem to date. Cedric Colvin from Akron Municipal Court asked how we're going to enter orders in cases when the Common Pleas Court doesn't have subject matter jurisdiction. we've consulted with a number of stakeholders, and although the appointment of the lawyer and the funding of the lawyer does not affect jurisdiction of the case, we do recognize that we are not going to actually put the journal entry on until the time that the case is bound over. And so we're going to hope that the criminal defense bar can work with one another to communicate effectively, so that if you receive a call from Common Pleas Court and you know that that's your client, you'll receive electronic notification both through the computer system but also by text, and you will undertake that representation. There'll certainly be a written record of it in our system, and then the entry will go on at the time of indictment. So thank you for that question. And again, if the case works out to a misdemeanor reduction, our hope is that we can finalize the process, that a lawyer from the legal defender's office will handle that misdemeanor reduction, and so that there's no question about which attorney is going to handle that reduction. Someone else asked, when will the felony appointment list switch from the twice yearly deadline to a rolling monthly application process? We begin this process on November 4th. So our intention is that in the month of November, we will use the information the Bar Association has for the current list, and we will provide you as the criminal defense bar with information about where to send your credentials in the event that you want to update that list by the end of November. So that gives us, a few weeks till the end of November to add anybody that needs to be added. To whom should private counsel direct changes in email or cell phone number? For now, we have developed, Judge Jones and Director Defebaugh, a central phone number and an email address. And I would encourage you to use the email address because I think that will allow us to have a written record of your request. Director Defebaugh, I forget, maybe you could just tell us the email address so I don't make it up.
It's a felony arraignments.
Plural?
Yes. Well, let me double check that, Judge. I'm sorry.
That's okay. That's a good, but
Yeah.
it would be at a regular extension, right?
Yes. Hang on one
And I'm going to
second.
type it in the chat box for all of you so that you
Right. Oh, boy.
But she believes it's felony arraignments at
Yeah,
CP
it's
Court.
felony arraignments with a capital F at cpcourt.summitoh.net.
And I'm confident that the F doesn't have to be capital. You can try that, Director Defebaugh, to ensure, but it typically is not case sensitive for an email address. And so what that means is that will be the email address that you can use to update your information for us. If that process changes, obviously we'll let you know, but we're trying to, every time somebody brings up some new issue, to roll with it so that we can make sure that we can provide that for you. I think I've addressed all of the questions in the chat box that were asked. So I may turn it back over to Judge Jones, and certainly if anybody has other questions. If you're not a great typer, you could raise your hand and we could try to address you, but don't just unmute and start talking. Thanks.
All right, thank you, Judge Oldfield, and thank you, Carrie Defebaugh, for that. Judge, were you able to, forgive me, I didn't hear, were you able to address when the rolling application would begin?
Did you ask me that?
Did you see that question?
Yeah, I addressed that, and I told them that we will start this process in all municipal courts on November 4. And so by the end of that month, if anyone has an update to make, we will update the list we've been given from the Bar Association.
Okay. All right, fair enough. And then did we have Magistrate O'Connor, just for the bar, cover the information regarding when arraignment dates would switch with us? Could we, just what you did yesterday, Magistrate O'Connor, just point that out to the lawyers?
So the last day for arraignments in front of the magistrate will be Friday, which is November 13th. So any indictments that are filed through November 4th will be heard in arraignments through November 13th. After that, the cases will be rolled to a judge and the arraignments will be held in front of the judge.
So Judge Jones mentioned earlier that we've talked to Attorney Young from the State Public Defender's Office, and I just want to, someone asked me this question just now, so I want to clarify that for everyone. We are not authorized to reimburse two different lawyers on the file, and we are not going to be authorizing conduct that did not flow through the Common Pleas Court, and our general division judges are unanimous on that. So just so that all of the criminal defense bar is aware, The lawyer who's appointed through Common Pleas Court is the lawyer that will have ultimate responsibility for the file and whose work will be authorized and paid for through the Common Pleas Court's fee application process.
Okay, and were you able to cover in your overview that if by some chance a municipal judge appoints a lawyer with a CRA number, that then that billing would have to be handled through that municipal court?
Well,
Or do you want me to cover that?
Yeah, I mean, we didn't really talk about the specifics. What I'll tell you is that the county has contracted for and is paying for an attorney to be there at the initial appearance who will have all of the information you would have already had. In the event that you receive a call, you will also get a notification from Common Pleas Court that tells you if you've been appointed at the Common Pleas level. So that will be up to you to work with your colleagues, recognizing that we will not be signing CRA apps and that 2 lawyers will not be reimbursed through the state. So please keep that in mind as you move forward. We think it's a simple fix that you can work together when you receive the notification from Common Pleas. In the unfortunate event that you're placed in a situation where another lawyer has also been given the appointment as well from some other jurisdiction, we hope you'll work together to recognize that the lawyer through Common Pleas is the one whose responsibility the file will remain with through its conclusion. I had a question in the chat box. What will happen to a municipal court appointment that will be, and then Brian Williams stopped typing, maybe, I don't know why you stopped typing, but what will happen to the municipal court appointment? Again,
I hit the wrong button.
What was that?
I hit the wrong button.
That's okay.
why
I do that all the time.
I
want to be clear with you.
Oh, hold on. Go ahead, Brian. Go ahead, Attorney Williams.
I'm sorry. Here's a question. I just got a call from Stowe today from Renee. I have an initial appearance November 9th. That's obviously going to be indicted after with this new system. Am I still going to be the attorney or is it going to go to someone else?
This process begins on November 4th. So beginning on November 4th, any initial appearance for any defendant who's facing felony charges will be handled by an attorney from the Legal Defender's Office. And Stowe has complete collaboration with us in that regard. And so to the extent that you have a question about that, I would encourage you to call Renee back. Maybe that just slipped through the cracks if she knows about a case right now. You're asking what will happen to a municipal court appointment. Again, we are not instructing anyone to ignore a court order or to, we're not instructing any judges in another jurisdiction. We have no authority over that. All we're telling you is that the felony judges have agreed to undertake the appointment of representation for felony cases, and those are the attorneys who will be authorized to seek reimbursement for that felony case. So again, if you have the unfortunate circumstance that you've been placed in a position outside of our control where you've been given an appointment and your colleague has received the same appointment at the Common Pleas level, please just talk to one another, recognizing that we will not be signing fee applications at the municipal level. One question was asked, if you have to do an interim bill for work by the end of December, does the bill have to be still within 30 days of the last hearing? That might be a question for Greta Johnson. Or maybe she said bye.
Actually, we had a conversation about that earlier today. This is Deb Matz. I think we're anticipating that if you, say for example, and I know it's unlikely, but if you had a hearing on December 30th, all right, since the cutoff is December 31st, you could include that hearing. We have, and I'm sure you guys have heard this deadline before, we have 90 days from the, basically whatever the last date is that's in the affidavit or in the fee app. We have 90 days to get that down to the Ohio Public Defender's Office to get it reimbursed. Generally speaking, we give you guys 60 days to get that app over to us, and then we take that 30 days to do all our cross-checking, and then we get it down there. So if you have a hearing on December 30th, you submit that fee app anytime before like the end of February, so basically 60 days, we will accept that and it will get sent down to Columbus. So you still have your 60 days from the date of the last hearing all the way up to December 31st of 2020. I hope that made sense.
Yes, thank you. A couple questions that were asked in the chat box. Will waivers of appearance for arraignments still exist as they do now if the defendant is out on bond without a pretrial issue. And I'm assuming that you mean at the common pleas level. And I don't see that we have changed that process. I don't know, I don't think we've talked as a bench about whether we individual judges are going to continue to allow waivers of arraignment. Judge Jones.
Well, you're right. I am an attorney, so I'd rather call me Amy. Actually, Joy, I'd prefer that. Actually, though, that's a measure related to COVID. So maybe Attorney Ross, I'm sorry, Judge Ross could weigh in on this as well. I'm just kidding, but I think we worked together from the COVID analysis perspective and came up with those arraignment entries. So from that perspective, they'll still be in place.
Okay. The other question was asked, what about an attorney who withdraws during the case or declines the appointment? Certainly, if you decline an appointment from us, and it's happened to me on occasion where I called a lawyer and said, do you want to handle this? And they're like, no, thank you. We'll just call somebody else and we'll send out a different notification that indicates who's responsible for that file. If you withdraw and the case hasn't yet been bound over, we're asking that you please, notify us so that we can put someone else on the file. Certainly, don't just not appear, because obviously that puts our municipal courts in a precarious situation where they have something perhaps set and then they don't realize who's on the file. So we're hoping that you guys will all work together to make sure that you are acting as you normally would. Attorney Immel asked if there's a hearing that occurred in September and the next hearing isn't scheduled until after the 1st of the year, will be outside of the 60 days for the interim fee app. But I think the idea here is you're going to bill for work you've done in a timely fashion within the 60-day period. And if you have a hearing set out later, you can then bill for that hearing as you normally would. It won't all be on the same fee app. Am I correct about that, Deb? Deb Matz?
Yes.
Yes. And then, obviously, depending on the time lag, this was brought to my attention from our Summit County Prosecutor's Office, from indictment to arraignment, many prosecutors may have discovery on the way by the time of the arraignment. And so the arraignment in front of the common pleas judge may end up being more like a first pretrial. That may be a wonderful thing. The whole goal of this is obviously, first and foremost, that we believe that we need to conduct ourselves in accordance with the fundamental philosophy that felony judges appoint and oversee lawyers who handle felony cases, but also the efficiencies that we have identified for you throughout the process. That will be one more thing that is helpful. Judge Jones, I think I've addressed all of the questions in the chat box. Alan has confirmed that.
I have just two questions for Attorney Kodish. Did he identify what lawyers were going to be in each municipal court starting on Wednesday?
Joe, I'm sorry, you're muted.
The answer is, I believe that I know Akron Muni knows, and the other two are the lawyers who have that rotation in Barberton and Stowe. So I would say yes.
Okay.
Okay, so they've been assigned for their court appearances for that Wednesday, and then I don't know if I missed either Greta, Deb, or you, Joy, addressing the fact. I think that the public defender's office, you asked Joe Kodish maybe yesterday. Have they designated a new executive director? I didn't know if an announcement was going to be made today.
I don't believe at this time it's going to happen. Probably first part of the week, I would guess.
You mean the announcement?
Correct.
Okay.
Oh, okay. All right. Fair enough. Then with that, Judge Oldfield, anything else?
I don't believe so. One question was asked about screens for specialty courts. Certainly to the extent that you have communicated with your client and you think a screen is appropriate, please, communicate that. We can do those screens pre-random assignment because it's a pretrial supervision function and an adult probation function. So certainly if you believe your client should be screened, we can have that information sometimes at the final pretrial. The whole goal is to get you as much information as we can and streamline and expedite these cases, handle them more efficiently and reduce jail days. So please, do that. And the other thing I would just say is that as lawyers, please make sure that you are not just communicating with each other, but also with the client. Because now it's a scenario where the lawyer who appears with them at the initial appearance is a lawyer from the legal defender's office who ultimately won't retain responsibility. So we are encouraging you, we're saving, a lot of time on your end from arraignments and appearances. Please take time within 24 hours of receiving an appointment and contact that client so that client understands who his or her attorney is. One attorney asked if pre-indictment issues exist after you have been appointed by our common pleas court and that results in a no bill. Is it proper for the attorney that we appointed to undertake the efforts to secure that no bill, and will you be compensated? Certainly, if you've been authorized to handle a case on behalf of a client by the Common Pleas General Division, then we will sign those fee applications. And to the extent it has not been randomly assigned to a judge, my understanding is it will either be signed by the administrative judge or by the designated appointing judge. Attorney Contreras, thank you. Judge Jones?
I think that's all that we have for today, unless someone else has any other questions.
Oh, I was sent a communication so that everyone understands who is there for the initial appearances so that it's helpful for you as private counsel. In Akron Municipal Court, Tim Corley will be handling the process beginning on day one. In Stowe Municipal Court, it's Attorney Barnhart, and in Barberton, it's Attorney Nichols.
Oh, okay, thank you.
Joe, correct me if I'm wrong, but I just got that communication.
That's correct. And with Akron Municipal Court, at least initially, what will happen is the attorney who is assigned to that particular judge will be in an interim basis handling the arraignments.
Anyone else have any questions for us? You're welcome to reach out if you do. We thank you for your time. Judge Jones, I'll let you and Andrea Whitaker wrap up.
I'm sorry, who wanted, Attorney Whitaker, did you want to make an announcement about something?
No, Your Honor, I was just going to say that if people, I'm sure as we all will have questions going forward and issues that need to be resolved, I'm happy as the chair of the criminal section, if people want to communicate those to me, aren't comfortable necessarily doing that in any other way, I'm happy to kind of act as a clearinghouse if people want to. I'm sure the judges, of course, wouldn't mind being approached themselves, but I'm also happy to act as a clearinghouse for those.
Oh, thank you. As the chair, you're willing to act as the liaison. We appreciate that announcement, Attorney Whitaker. Thank you so much.
The other thing is that we did receive a question that if an individual attorney is appointed in municipal court and the client fails to appear at the common pleas arraignment, are you still on the case? Again, starting November 4th, the attorney whose work is authorized and who's responsible for the file from the General Division Common Pleas perspective is not the attorney that was assigned in municipal court. So I don't understand that question, Attorney Agarwal. You said if you were appointed in municipal court and the client failed to appear at the common pleas arraignment, are you still on the case? Are you talking about cases for which you were appointed prior to November 4th? If that's the case, yes.
Well, hold on. Let's see if Attorney Agarwal, are you there?
Yeah, he chatted it. He said, yes, that's what I mean.
Oh,
You're
okay.
welcome to unmute, Neil, if you want to clarify.
Yes, I just meant if you were already previously appointed, like in June or July, and you got appointed, and then you appeared at the initial arraignment in front of Magistrate O'Connor, and there's a capias now, and then he's eventually picked up. Will new counsel then be appointed when he's picked up?
We're going to keep up through November 4th. Lawyers who were appointed to the municipal courts, we're obviously not removing counsel. So those attorneys will remain responsible for those files unless you withdraw. Our process change begins on November 4th. Starting on November 4th, any attorney appointed through common pleas is the attorney who will have ultimate responsibility for the file. Anybody else?
Any other questions or announcements that anyone would like to make?
This is Tammy O'Brien. Hello. I I just thought on a different topic, maybe since we have all of these defense counsel here, that we should remind them that the jail procedures on Monday are going to change. I told a few people yesterday in call day, but I think that defense counsel would be, would do so that they have that updated information.
Awesome.
And we just included that in the examiner that we just emailed within the last half hour. So we've sent it out to members a couple times, so people should have that in writing to be clear.
Okay, great. Thanks.
Thanks, Alan. All right, any other announcements or questions? All right, well, very good. We hope
Thank
you
you.
all have a
Thank
safe
you,
weekend.
everyone.
Thank you.
Bye-bye. Stay safe.
Thank you all.